which continued the hearing that was conducted on the 16th of November until today. As you probably know, we are in the middle of a unique legal process. We are in town hall, and we have parties here that have either spoken or would like to speak at some future moment. A couple of observations, if you will, since the last hearing. We were in private session. We're governed by a statute, for the record. The statute is better known as the Florida Land Use and Environmental Dispute Resolution Act. It's in the Florida statutes. It's section 70.51, chapter 70, which is a whole chapter regarding land use, zoning, and related development matters. And the section of the statute which has been implemented by both parties is a section which converts my role from a special magistrate conducting a full and final recommendatory hearing to essentially a mediator. And the statute tells us that the first responsibility of the special magistrate is to facilitate a resolution of the conflict between the owner and the governmental entities, to the end that some modification of the owner's proposed use of the property, or adjustment in the development order, or enforcement action, or regulatory efforts by one or more of the governmental parties may be reached. Accordingly, the special magistrate shall act as a facilitator or mediator between the parties in an effort to effect a mutually acceptable solution. The parties shall be represented by, at mediation, by persons with authority to bind their respective parties to a solution, or by persons with authority to recommend a solution directly to the persons with authority to bind their respective parties to a solution. There's other parts of the statute I could read, but that's the essential portion which both parties implemented when we met on the 16th of November. A couple of other observations, if I can. The first of which is that at the time of the hearing on the 16th, a number of people spoke at the podium, and all of your comments and statements are of record and made part of the proceeding. Subsequent to the hearing, I also received some letters which are in the record. I've forwarded them both to counsel for both the town and for the petitioner. One letter from the American Indian Movement of Florida, dated January 4th of 24, from Robert Rosa and others, which is in the record, has been transmitted to both Mr. Baird and to Mr. Nelson, and otherwise to the clerk for filing. The second letter was an email from the Caney, that's C-A-N-E-Y, Indigenous Spiritual Circle Elders Council, dated 1/9/24, from Miguel Sague, S-A-G-U-E, which was sent to me and forwarded directly to special counsel for both the town and for the petitioner. Those are also in the record. I also received emails from Sheridan Murphy on 1/4/24 and from Terry Grooms, who was a speaker at the last presentation, on 12/27/23, both of which were also submitted to counsel of record and are in the public record as part of this proceeding. In the last session we conducted, they're called private sessions. As I mentioned during the November 16th presentation, the law authorizes there to be an open public session, which there was in November, which broke into private session, and we've been meeting in private session since that time. For the record, in those hearings or private sessions was Mr. Baird as counsel for the town, along with the city manager, Frank Kitzero, and I believe Mr. Kitzero will be with us today as well. Also, on behalf of the petitioner was Mr. Howard Nelson, Mr. Philippe Jack, and also Ileana Kozlowski, an attorney with Mr. Nelson's law firm, and the owner of the property, Mr. Charles Modiger. We met in private session, and no other members of the consulting group on behalf of the petitioner were present during the private session. There was an objection raised during the course of the opening statements in November about their presence in the private session. Let the record reflect that the only parties in the private session were those that I mentioned, and they were segregated and kept separate. I was fulfilling my role as a magistrate mediator during those conversations that occurred. We spent the better part of the day, as you probably know, having multiple exchanges. Since the time of the mediation, there was a stipulation signed at that time, and the stipulation agreed to continue this hearing until sometime in February. I had a privileged status conference with lawyers several weeks ago. The objective was to schedule this as a reopened public meeting to then repair into private session, and the notice was published by the town clerk on December 20th, 23, continuing the hearing under the statute to today at 1:30 p.m. So in a few moments of time, I'm going to break from this public session. I don't know where I'm going physically, but I think I'm going into the new building across the way where there will be private rooms. It is not a public session. Each of the private sessions are legally privileged and are legally confidential and private. The only one who can know about what's being discussed in either room is me. That is that unless any information from either side is to be transisted from one side to the next, I cannot transist that information or transfer that information. What that means from a lawyer's perspective and from a layman's perspective is we're in a specific mediation process right now, where I'm a listener and I'm a facilitator in following the guidance and the requirements of the statute. Having said that, we could be in a mediation activity this afternoon from now until tonight sometime, or we could be done in an hour. I don't have an answer. I've had no independent, additional discussions with the representatives of either side since November the 16th. So today will be that day. If there is any specific issue that I can address with the public members that are here today, I will do so in between, if there's at all possible. The likelihood is that we will continue the mediation process until undirected otherwise, or the parties do what's called an impasse. I would hope that the parties do not impasse. I will tell you one thing though, or several things. There's been some extreme concerted effort and good faith on both the petitioner side and the town's side to continue a very open dialogue with regard to this very, very important matter. I take this issue and this matter quite seriously. I'm sitting here in the capacity as a near judge. I'm not wearing a black robe, but I'm wearing a dark suit. I don't get to tell people what to do legally in mediation, but I do get to steer information from one side to the next. Under state law, both parties were charged with the absolute unequivocal obligation to negotiate in good faith. As I said to you earlier during the opening, if you were here on the 16th of November, I know the lawyers involved. I know them for many, many years. In fact, for the record, Tom Baird used to work in my law firm 30-something years ago, round numbers, when he was a younger man, a little older now. And Howard Nelson used to work with a client of mine, the South Florida Regional Planning Council. I worked with Howard before he became a lawyer. I have no other connection or relationship with either lawyers or the parties. I've done some work for the town of Jupiter from time to time, but I do not do work here. I'm not the city attorney. Our law firm represents about a dozen cities in Palm Beach and Broward counties and a number of other special districts statewide, mostly in South Florida. I'm a city attorney. I do the same kind of work as Mr. Baird does for other governmental agencies. But today I'm in a very uniquely specific role. I was assigned the task of being a magistrate in what's short version called fluidity hearings. These are very unique aspects of Florida law. I would not choose for you to think that when we break from this session, when we essentially recess from the session, that your thoughts, your interests, or the things that matter to you, into the organizations you represent or to you individually, are being cast asunder. That's not true. They're all part and parcel of the overall record, because in the event that the mediation process fails, what that means is that I would then have to conduct a full-blown hearing, evidentiary hearing, where people are sworn, testimony is taken, and then the statute requires that I, as a magistrate, provide a recommendation in order to the city council, to the town council. And that's an elaborate process, and hopefully we don't have to get there, but the process is what it is under state law, and I'm charged with that responsibility by sitting here in this capacity. So I have had exchanges with both Ms. Murphy and Ms. Grooms, advising that this is the public portion, but there's no continued public hearing yet today because we're still in private session. But I did not want for you to not know that as we sat in this room. Sometimes things like this seem very mystical and very out of the ordinary. To some great degree they are. This kind of proceeding is not commonly done in many cities, many governmental agencies, but it is a part and parcel of Florida law, which has been implemented by both the petitioner and by the respondent as well. Council, do you have anything you want to open with, or are we going to just follow the direction from left? I'll give it to you, Mr.
No, sir.
Petitioner. Council?
No, Your Honor. Thank you.
Thank you. I'm grateful that you all showed up today to be here. I understand. I am empathetic to the issues that affect those that are in this room. I've read the documentation in the backup. I've read and reviewed and digested the information before you all got here, before I got here as a magistrate. And to that extent, I don't choose for you to think that we're undignifying your role relationship. I drove here this morning knowing the traffic was going to be pretty crummy. It's a pretty lousy weather up 95, a lot of delays and whatever. You all could be someplace else today. You all could be at work or home with your families or doing something independently of that. Very often when you go to a city council meeting or town council meeting, it's not typical for the mayor and commission to thank you for coming, but I'm going to thank you for coming. Not that they wouldn't, by the way. But I know that this is out of the ordinary, and to that extent, I thank you for being here and for your commitment to the process that we're in and to the committed issues about which you're actually committed to. That being said, I'm told and I thank our city clerk, Stephanie, thank you for being here, and your staff's assistance. I know that this is also historical because this building will soon be closed. And the activities of the town of Jupiter and the things that occur with local government will not be any longer in this building, but across the way in a new building with a new vista and with new opportunities. So I'm told that when we leave this room and repair, we're gonna go to the new building, to 2 separate rooms. Following the process that is required by statute, I'll be meeting with the petitioner first and with the town thereafter. In mediation matters, there's no time clock. Although the hearing notice indicated 1:30 to 5:30, I'm here until the matter can either be resolved or otherwise continued into a form of continued discussion. The law requires that if there's continuing discussion, it can continue. There's no specific time frame. The parties agree by the statute to keep the dialogue open and not to close that dialogue. I must do that as a special magistrate. So we could be in the next set of rooms for an hour or 2 hours or 5 hours or 10 hours. I'm committed as the assigned member of this particular position I'm in to spend whatever time it takes to meet with the parties. This is not my first rodeo. This is not my first sit down as a special magistrate. It's not my first time in a public building handling a matter like this. But I spent 2 nights this week in the city commission meeting and went very late, both evenings, and recognized the fact that the public has a right to know. Public has a right to know what's happening in Florida and to be heard as if and when the law permits that. This is not that time today, but I don't choose you to think that you would not recognize. I'm not going to open up to any questions, but I needed to put this statement on the record. I'm appreciative of your presence. I hope that you will wish us all the best of good luck in the context of conversation. There will come a time shortly when whatever occurs in the private sessions will become public. There's no recording machine, there's no video, there's no cameras, there's nothing except the lawyers and their representatives. The statute is absolutely clear. There must be a client there who can make decisions or can make a recommendation for decisions, and I expect that to be the case this afternoon. I've had, again, some conversation with counselors of record. They're prepared to act in good faith with their clients and to take heed to what the statute requires, and continue this good faith conversation with regard to resolution of the matter currently before me and ultimately before the City Commission, City Council. I want to thank you again. It's approximately 1:43. It is January the 11th, 2024, and Madam Clerk, we're going to recess this proceeding for now and repair to the next location we're directed. Thank you all very much.